Thank you. Thank you.
Good afternoon. Let's try that one again. Good afternoon.
Good afternoon.
Thank you. Well done. Well, it's a real delight for me to welcome you all and to welcome back Dean Kagan.
Justice now.
Justice now. And also at a time, General Kagan. So how's the campus look?
It looks fantastic. Wow. The last time I was here, I think that wing on Pound had not been taken down, so you couldn't really see this building. And now it looks tremendous. And the landscaping's all in. Before it was like a lot of fences.
Right.
So good job, Dean.
It's we now have half Pound. We took down part of Pound.
Half Pound. That's fantastic.
And this is the building that was designed by Dean Kagan. Who likes the building? Down to the carpet.
A lot of it was paid for by Dean Minow. So I thought that this was a fair exchange of labor, division of labor.
Still being paid for,
yeah.
for. But you picked out the carpets and the furniture. And
now if they don't like the furniture, it will be my fault.
That's a good allocation. So I'm very, very grateful that you're here and you're willing to answer some questions. I'd like to actually take you back before the current job. You've had a lot of different jobs. You were in private practice.
I used to change jobs all the time.
There was a time that you told me you'd never been in a job more than 4 years.
Until I became dean. That was the longest I was ever in a job, and I was only in that for 6 years.
Couldn't hold a job.
Couldn't hold a job.
But you were in private practice. You were at the White House in the White House counsel's office. You were deputy chief of counsel. You were described as the White House all-purpose brain.
That was a specific job in the building.
You were a professor and you were a dean. You were then Solicitor General of the United States. And so one question I have is, what do you draw upon in your current work from those prior jobs? And then in particular from the Solicitor General's role?
Well, I draw a lot on being a professor, being a teacher. We can talk about this in more detail. When I write opinions, when I think of what kinds of questions to ask, I think about the way I would prepare for class, the way I would explain legal concepts to people who didn't know a lot in the first instance. I would think of the kinds of hypotheticals that I used to pose to students and whether those kinds of hypotheticals would elicit interesting information at oral argument. So there are many ways in which my experience as a professor helped me as a justice, including, of course, that I thought about some of the topics that I deal with, especially some of the constitutional and some of the administrative law topics. But I think you're right to focus on the SG position. I was only in that job for about 15 months, but it's almost the closest thing to being a Supreme Court justice than a Supreme Court justice. I mean, in some ways, it's a better preparation, I think, than being a lower court judge, because what the Solicitor General does is basically think about the Supreme Court all day long. The Solicitor General represents the United States in the Supreme Court, along with supervising the lawyering that goes on in all the appellate courts. But it specifically represents the United States in the Supreme Court. So once a month, I would go to the Supreme Court and I would argue cases, and the Solicitor General herself usually argues, the most significant case. And then you superintend all the brief writing and all the cases that the Solicitor General that the United States participates in. And that's a lot of cases. The United States participates in either as a party or as an amicus, a friend of the court, participates in about 70% of the cases that the Supreme Court hears. So you're constantly thinking about the court and the court's docket, about how to persuade the court, about how to argue before the court, about how the court's procedures work, about what the justices are thinking about. One way you could say it is the Solicitor General's job is to try to figure out how to convince 9 Supreme Court justices, and the thing that's changed now is that I only have to figure out how to convince 8 Supreme Court justices. But by doing the Solicitor General's job, I really got a kind of crash course in the Supreme Court and how it operates and what the justices were thinking about things.
Also a role even in the cases that are not yet set for argument, right? Deciding whether or not to weigh in on applications?
Sure, that the Solicitor General decides which cases to take to the court. There are lots of cases that the United States may lose, but we don't petition the court to take all of those cases. So Solicitor General tries to figure out, and often looking at it from the court's perspective, is this the kind of case that the court is going to take? Does this fit the court's criteria for what cases ought to go up there, or are they just going to laugh at us when we ask them to take this case? So trying to figure out from the perspective of the court as well as from the perspective of the United States government what cases to take up there.
So just two more questions about this. One is, as the chief legal officer for the United States, you had to deal with different agencies, and they didn't always agree. So what's the role of this kind of a legal actor looking across different agencies?
Yeah, it's one of the most fun parts of being the Solicitor General, is that the Solicitor General often is in a position where different agencies or different parts of agencies are pressing different positions, pressing different arguments, and you have to figure out the position that the United States is going to take and the arguments that the United States is going to make. And so often you call these meetings and there are just a slew of people in a room all pushing their preferred position. I'm looking straight at Charles Fried, who was the Solicitor General extraordinaire and knows what I'm talking about. And you would get all these people in a room and they would all be pushing their positions and you would have to decide. It was interesting. At first, you'll appreciate this, I think, Dean Minow, because part of the dean's job is, you know, you have 80 or 90 or 100, whatever it is, faculty members.
110.
Yeah, 110, and they're all pushing different things and to try to sort of negotiate and arrive at consensus and arrive at a position that everybody can live with. And at first, in the Solicitor General's office, I started by thinking of that model. I started by thinking of like bridging differences and arriving at consensus positions. And then I realized that they actually did not expect me to do that. They just expected me to decide. And I thought, what a change and what a refreshing change, really. It's like all these people. I mean, if we reached consensus, that was good. I mean, nothing wrong with consensus. But if we didn't, everybody thought, okay, that's the ball game too. That's all fair. That's her job. She gets to decide these things. And as long as everybody felt listened to, I felt as though, you know, sometimes I could not do the kind of bridge building and consensus building thing, but instead actually say, you know, I've looked at you and you've presented me with 6 different positions, and, you know, I think position 4 is the right one. The end.
Did you did sometimes need to go to the White House, though? It wasn't just always your call.
You know, very, very rarely.
Very fewly?
Yeah, I mean, almost never. And I think that that's consistent with other Solicitors General in other administrations, is that, you know, every once in a while there'll be, you'll hear what the White House would like, but the Solicitor General's job is a very autonomous one, that there's a view, I think, in most administrations, certainly there was in this one, that it was to be independent in, you know, the vast
Right.
majority of cases and situations, and it was your call to make. And indeed, there's even a little bit of independence from the Attorney General, your direct supervisor, where it would be very rare for the Attorney General to get involved in a decision that sort of fell within the ambit of the Solicitor General's office. So I don't want to say
Sure.
never did I hear what either of those two individuals would have wanted, but I think as in most administrations,
Very rarely.
truly rarely.
So the last question on this series is compare Solicitor General role with being on the court, 10th Justice versus 9th Justice. You've indicated one way in which it's different, how many people you have to
By the
persuade.
way, the court, I think, does not view the Solicitor General as the 10th Justice. I mean, the court views the Solicitor General as important, and
Yeah.
one hopes that the court respects the Solicitor General and respects the Solicitor General's office. But this 10th Justice phrase, which you know, is a pretty old phrase,
Sure.
I think the court is like, no. There are 9 of us. That's a good odd number. That's fine.
So asking questions versus answering them. Better, worse, harder?
Oh,
scary?
asking them is so much easier. I mean, that's what I try to think about, actually. What I try to remind myself of is that answering them is hard. And when you stand up at that podium, it's a really tough thing to do because we don't give you much time to collect your thoughts and to express yourself in all the ways that you practiced in front of the mirror. Maybe you stand up at the podium and you get a sentence out, 2 sentences if you're lucky, and then the questions start and they don't stop, usually, not always, but usually, until you sit down half an hour later and you're just bombarded. Yeah. And in order to be, this isn't true of all courts, it's not true of all appellate courts, but it is true. There are 9 people, we only have an hour, half an hour with each attorney, usually, sometimes even shorter, 20 minutes with one, 10 minutes with another, that sort of thing. And we all have a lot of questions, and we bombard them, we batter them, and sometimes we don't even. Sometimes we talk a lot to each other, and the poor person standing at the podium is really just sort of a way to communicate with your colleagues. We're not really actually all that interested sometimes in what you have to say. We're a little bit more interested in talking with each other, and there are reasons for that. I think sure. There are good reasons for that sometimes. But it's really hard to be up there and to face this sort of onslaught. Yeah. And so I try to remember that and try, to at least be polite.
I think yours has been described as a hot bench. It's a very animated group of justices who ask a lot of questions.
People say, I think this is probably right, that everybody recently who has retired from the court has been replaced by somebody who asks more questions. And I think that that's probably true. I know it's true in my case that Justice Stevens used to ask great questions, always questions that went to the real heart of things, but he was very, very economical. And I'm afraid to say that I'm not quite as economical as that. And I think that that's been true of a lot of the, I think Justice Sotomayor and the Chief Justice and Justice Alito, all the recent appointees are probably asked more questions than the people that they replace. So it's, at this point, we're a little bit tripping over each other.
And the fact that you're from New York has nothing to do with that.
And four of us are from New York, yes. So who knows whether. But some of the non-New Yorkers do pretty well. Yeah.
Now you mentioned that sometimes.
It's part of the reason we love Justice Thomas. We do. We love Justice Thomas.
Because he's not from New York.
No, he's not. Like, if it were 9 justices asking questions, I think Justice Thomas thinks we're all ridiculous. It's like, would you let the person talk? And he has a point. So it's like...
not long ago we were so honored by Justice Thomas coming to spend time here on campus, and I asked a question. I didn't say, why don't you ask questions at oral argument? I instead said, what do you think about the fact that your colleagues ask a lot of questions at oral argument? That was pretty good, right? And he said, well, I really don't have to ask any because if I just wait, they're all going to be asked.
Yeah. Yeah, he's a fantastic man, and really, I think he kind of thinks sometimes, and I think he sometimes has a point that it's like, really, enough already.
Let them do their thing. Yeah. You mentioned that often you and your fellow justices are actually talking with each other, but it's an odd art form because it's in the form of a question. You're not actually turning to each other and having the conversation.
Yeah, sometimes. I mean, sometimes I'll ask a question and then I'll realize that really didn't seem like a question, it really seemed like a statement, and I kind of want to say, just put a question mark on that,
Right,
so
right.
Sometimes they're questions and sometimes they're sort of statements with a question mark at the end. But it's I think that the reason is that we talk to each other first at argument. We don't get together and talk about a case before argument. Argument is the first time that as a group we're talking about a case. I mean, maybe there's some individual chit-chat between one justice and another before argument, but not as a group, certainly. And then when we go into conference, a couple of days after argument, we go around the table and people, each one by seniority, talks and then says how he or she is inclined to vote. And so everybody, so I'm the ninth person. So if you think about it from my perspective, I don't really get a chance to say anything at conference until everybody has already indicated an intention about how they're going to vote. So to the extent that I have something that I think is a slightly different take on a case, or something that I want my colleagues to hear before they say how they're going to vote, argument is the time for me to do that. And I think we're all aware of that argument is a time when one can put ideas into your colleagues' heads. And especially if they're ideas that, that aren't kind of like straight out of the briefs, that are a different, new way of looking at things, a way that might not have occurred to your colleagues, or if you think you have a different sort of critique of an argument that seems to be gaining sway at argument, the argument is the time to do all of that, to put the ideas out there, to put the criticisms out there, so that people hear them before they go back to their chambers and they mull things over for a couple of days and then they come into conference.
How do you prepare for argument?
Well, I read the briefs really carefully. I mean, people sometimes say, how much does argument matter? And the argument itself sometimes matters, but matters less than the briefs. I mean, if you're going to rank order, which is more important by far, the briefs are more important. So I spend a lot of time with the briefs. I read the briefs, the parties, and frequently the amicus briefs. Not all of them necessarily, in every case, but I look at which parties are filing amicus briefs. I look at which lawyers are writing those briefs. I ask my clerks to.
Summarize.
They have to read all the briefs, and they tell me which ones I should pay close attention to. So I spend a lot of time with the briefs, and then I talk to all my clerks. I have one clerk write a bench memo, and that bench memo is just supposed to be a kind of my take on the case. If I were a judge, this is the way I would think about it. And that
You have 4 clerks.
I have 4 clerks, but that one person does that for every case, and that provides a kind of launching pad for a conversation to take place. But I talk not only to the clerk who wrote the memo, but to all of them. And one of the things I tell them at the beginning of the year, and sometimes I remind them of them in the middle of the year, it's more helpful to me actually if they disagree with each other. So I don't really want manufactured disagreements, but I certainly don't want them to suppress disagreement, because part of the way I think through problems is to talk through problems and to listen to other people give me their views, and to think about like what sounds better to me. And so, we have a conversation, and in the easy case, that conversation can take 20 minutes, and in a hard case, it can take, an hour and a half, or even longer. And then I'll go into argument, and one of the things that we do when we talk about the cases is we'll all talk together about what kinds of questions it would be useful for me to ask, so I think about that as well. And then I go into argument, and then when I come out of argument, sometime in the next 2 days, between the time of argument and the time of conference, I'll meet with my clerks again, and we'll sort of talk about whether anything new came out, either any new arguments that the lawyers made, or anything new that we learned about how my colleagues were inclined to deal with the case, and we talk about, whether anything's changed, and then I'll make up my mind.
So you have some special functions as the junior justice. What are those functions?
They're very difficult tasks. They're very serious tasks. When we go into the room, the conference room, it's a great room actually. Makes you feel very judgely being in this room, we go in without anybody. It's just the 9 of us. We don't bring in any of our clerks. There's none of the court staff that comes into the room. We actually don't bring in laptops or iPads
Really?
or anything like that. So it's sort of just
You
like,
let go of your phone? That's amazing.
yeah, there you are. It's just like us and our notebooks. And but sometimes people will forget things, or they'll need things. Like I forgot my cup of coffee, or I forgot my eyeglasses, or I failed to bring the crucial file. And so they'll get on the phone with their chambers, and somebody will come and then there's like a double door. It's like not enough that you have one door. And they'll knock on the outer door, and then I have to hop up and open the inner door.
That's your job.
Truly, if I don't do it, nobody will. If I don't do it, like they'll just all stare at me. Elena, that was a knock on the door, you know? So I, you know, I open up the outer door and I get somebody's eyeglasses or somebody's, you know, whatever. That's one part of my job. The second part of my job is I take notes on everything that we do, and I actually convey what we do to the people who have to know about it, primarily to the clerk's office, to the
disposition.
Yeah, so, you know, we denied this case, we GVR'd that case, we held this case, we
GVR means?
grant, vacate, and
Thank
remand. We granted this case, that sort of thing. So I convey our actions.
But sometimes you're getting up to answer the door and you're taking notes.
Yeah, it's hard to do both at one time. It's like walking and chewing gum or something like that.
Now, at some point, you told me that you were also, because of your role as junior justice, put on the cafeteria.
Oh yes, that's my third job.
Oh, yeah.
Yes. Yes. It's like a humbling experience, I think. It's like
You're being hazed.
Exactly, right. It's like, what's the worst committee to be on? The Cafeteria Committee. But you know, like when I was dean, I kind of
Cafeterias
created
are great.
that cafeteria.
You sure did.
Yeah.
It's really great. Soft serve ice cream, you like it?
Anyway, hope it's good. But the chief there's a fantastic guy in the building called the counselor to the chief justice, and he came to see me my last day as Solicitor General on the day before my confirmation, and he said, I just want to prepare you for all these things that are going to happen, and we should talk about your investiture, and we should talk about this and that. And then, you know, one of the things he said was, and you'll be on the Cafeteria Committee. And I said, you know, I do cafeterias, you know, but I actually don't do very much on the Cafeteria Committee.
You are the youngest of the justices.
Justice Breyer was on he was the junior justice for like 13 years on the Cafeteria Committee.
Wow.
You know, because there was just like no
Nobody.
movement in the
Wow.
court, right? So 13 years later, he was still opening the door.
You are the youngest of the justices, but when you're in the room with your clerks, you're the oldest in the room. So you're kind of between, I don't know, what's that like to cross over the age groups?
Yes, I lack peers. Is that what you're going to say?
Something like that.
No, there are a few of us. There are a few of
Yeah.
us who, you know,
Yeah.
are sort of the same age range. But I don't know. I love having clerks. And I love talking to young people as part of, I guess I loved that when I was here
Teaching.
as a professor, as teaching, and you know, in some ways it keeps you young to talk to young people all the time. But then, you know, it's sort of nice, sort of feeling like you're you know, I'm like coming up on 55, right? So this
You're
is
a
not
baby.
this is not young by any means.
Yeah.
But when I get together with my colleagues, I feel kind of young, you know. So that's good, you know.
When I was last at the court, I was talking to one of the guards who said, we can always tell when Justice Kagan is coming down the hall. I said, how can you tell? They said, she walks fast.
That's because I'm a New Yorker.
So I'm sure many people here are curious about your relationship with your colleagues. It's much discussed. Are there friendships? How can you be friends with people with whom you disagree? You have majority opinions with sharp dissents. So do you spend time together? How do you relate to each other outside of the judging work? How do you deal with the fact that you do disagree and then need to see each other the next day?
Justice Scalia said to me, and I've heard him repeat the line on a few other occasions once. He said to me, if you take any of this personally, if you take the disagreement personally, you're in the wrong line of business. And I think that's right, and I think, he and others are a great role model in that. I mean, we do disagree, and we are going to disagree, and about important things and about matters that we care about. But I think you just can't let it affect your personal relationships, and you have to go in knowing, and I believe this with every fiber of my being, that that people are all operating in good faith and trying to do the right thing and taking their jobs extremely seriously. And sometimes you're going to reach different outcomes. And again, different outcomes on things people care passionately about. But those are the issues, and the issues are different from the people. And I think it's an incredible group of people. Smart, engaged, interesting, personable, really decent people, and I enjoy being with them, and I enjoy, honestly, sometimes the folks who I disagree with are really among my favorites to spend time with.
Speaking of which, are you going hunting again with Justice Scalia?
I am. So Justice Scalia and I are going down to Mississippi this December, and we're going to hunt ducks.
Ducks?
Yeah. So
have you done ducks before?
I've not done ducks before.
Wow.
Yeah, Justice Scalia and I usually we shoot birds, quail and pheasant, and then once, I think you asked me about this.
I did ask you about this.
Once we went out to Wyoming to shoot deer and antelope, and you sort of looked at me and said, "You shot Bambi," or something like that. And the answer was, I did. But we're going down to shoot ducks. And the genesis of this was, I'll tell the story. I've told the story about 1,000 times. But
tell it. It's a good story.
The genesis of this was, I was asked just a ton of questions in the confirmation process by Democrats and Republicans alike about my views on gun rights, Second Amendment issues. And people can't ask you, like, how are you going to decide this case, or how are you going to decide that case? So they have to find proxies, ways of sort of trying to scope out what your views are. And the natural proxies that people used, they just asked me a lot of questions. I felt like there were so many interviews of these courtesy visits that you do with, I did them with like 82 senators, and so many of them, people would say, have you ever hunted? And have you ever owned a gun? And do you know people who hunt? Do you know people who own guns? And, I grew up in New York City. We didn't go hunting on weekends. And I failed these questions miserably, and, failed them from their point of view because, I had really nothing to offer. And I was talking to one of the senators from Idaho, and he was telling me about that he did a lot of hunting, and that this was, very important to a lot of his constituents, and to understand the culture was something that he was worried that I just didn't get. And I said to him, Senator, I said, I got to tell you, this is not something that I've ever encountered the opportunity to do in my life, but if you invite me out to your ranch, I would love to go hunting with you. And he looked at me with just this total horror, like, did this person just invite herself to my ranch to go? And when you thought about it that way, it was a little bit beyond the bounds, right? And so I said, well, Senator, I don't really mean that, you have to invite me to your ranch. But I said, I'll make this promise to you that if I'm lucky enough to be confirmed, I'll ask Justice Scalia, who I know to be an avid hunter, to take me hunting. And when I got to the court, I went to Justice Scalia and I told him this story. And I said, this is the single promise that I made in 82 courtesy visits. Would you? And he thought it was hilarious. He thought it was funny, and he said, and he was fantastic because he has these hunting groups and these hunting buddies. But he's like always, do you want to go Saturday? Do you want to go Monday? Do you want to go Thursday? I can go hunting with Justice Scalia like every day. And he loves it, and it's fun, it's actually a lot of fun. I found it to be a lot of fun, so I really enjoy being with him. I really enjoy doing this. Not as often as he does, but yes, we go hunting together. And he tells me ducks are really fun. So So ducks it will be.
Who's the funniest justice?
Well, Justice Scalia is, I think. Yeah. I mean, just, you know, do you know that there's something that keeps track of the laugh lines? There's somebody out there
Counting?
who just counts all the laugh lines
In your
the
transcripts?
Supreme Court transcripts.
Wow.
And it turns out that Justice Scalia and Justice Breyer, I mean, are like lap the field 10 times. I don't do very well. Somebody,
Really?
one of the people who does this counting
I'm surprised.
once wrote on one of his blogs or something that I was underperforming what they knew to be my true potential, you know, but there you go.
But are these just how many times somebody laughed, or is it how long the laugh is? Because maybe your laughs are longer.
That's the problem. That's
Yeah.
the problem.
Oh.
Yeah. No, I don't know. You know, I sort of feel like there's so little time to ask questions as it is that the idea of like cracking jokes up there seems for a junior justice to be a little bit much. So, but you know, Justice Scalia is incredibly funny. Justice Breyer is incredibly funny. The Chief Justice is very, very witty and very, very fast. So he's really, yeah. So you know,
You enjoy each
and other
other.
people occasionally surprise you. You know, Justice Ginsburg loves it when she makes people laugh because people don't really expect it, and then it's like, you know, I'm funny, which she is.
Let's talk a little bit about writing and your opinions. Your opinions are already gaining a reputation for being distinctively readable. So I'd be interested to hear who you think are the audiences for your opinions. What do you do if you do something conscious to make them readable? What is your goal and how do you write them?
Well, I do want them to be readable. I mean, sometimes I ask myself why, because in some of my opinions, you know, probably only experts are going to be reading them. It's not like every person on the street is going to pick up some of my opinions on abstruse and arcane subjects. But still, I actually tried to make them so that if there was a person who did that the person would be able to understand what I'm talking about and you know, both the outcome and the reasons for the outcome. And I think in some sense, you know, we owe that to all the people who deal with our work, obviously to lower court judges and to litigants and their lawyers, but you know, but also to the ordinary people who are interested in what we do, to the extent that there are and are people, and there will be more in some cases than in others, but that's okay. And what do I do to try to make them readable? I mean, mostly I spend a ton of time because I think good writing just takes a long time. And especially I think good legal writing takes real work because some of these subjects are really complicated and they're foreign to people and they can sound really arcane. And to try to explain what's at issue and why it matters in a way that people can understand, you know, just it takes more than one draft, and so mostly I just, you know, work at it and work at it some more.
The journalist Lincoln Kaplan calls you the master of the topic sentence.
The master of the topic
And he
sentence.
quotes several
Wow.
of them. A trip back in time begins to show why was an example. And another, he also says...
Sure, we can do better than that.
He also says you're the master of the stylish dig. And his example
That's a good
here
thing to be.
is
Okay.
wrong.
I like that one better than
like
the
that
master
better?
of the topic sentence.
Okay.
Although I do, you know, I tell my clerks topic
Topic
sentences are
sentence, well,
really important.
It
in
clearly
term-
comes
yeah.
through.
Yeah.
So stylish dig, this was his example. Wrong, wrong, and wrong again.
Well, I think we can do better than that too.
But he says, and others have said so too, that you're in a class by yourself in the down-to-earth writing and the ingredients that make an influential opinion, including insight, clarity, and verve.
Well, I think there are actually a lot of excellent writers on the court. I think it's one of the things that this court is notable for, is that there are really some truly excellent writers and you know, I learn from some of my colleagues. Sometimes one of the ways to be a good writer is to read good writing. And sometimes you read briefs and you think, every moment I spend with this brief, I'm becoming a worse writer. But I often feel the opposite with some of my colleagues' writing, is that every moment I spend with somebody else's opinion, I become a better writer and I see new and better things to do.
The attention to the United States Supreme Court, and indeed many high courts, is usually given publicly to the most controversial decisions, the ones that divide the court, the ones where there are sharp 5-4 decisions. And I wonder whether there are other cases that aren't so divisive, that aren't so high profile, that you wish got more public attention.
Well, I guess the first thing to say about that is that it would, what doesn't get public attention is how often we agree. And because, for the most part, people do focus on these cases about the hot button issues in which frequently we are divided, and sometimes we are divided along fairly predictable lines. But there's like this whole world of our docket out there where we actually achieve remarkable unanimity. So I think over the past several years, it's been at least 50% of our cases. I think it's been 50% is sort of the norm of unanimous decisions. And then this year, we were way over 60%. Yeah. It was like 65% or something like that. And these are hard cases. There's nothing easy about most of the cases that we take. Mostly we take cases because the issues that they present have divided the lower courts. So these are cases that almost by definition have divided other judges. And yet they come to us, and very frequently, all 9 of us agree on the right answer to it, and often agree as well on the reasoning behind it. So I think, this year it got some attention because we were so high on this measure of unanimity, and then some people argued, was it faux unanimity, because sometimes we agreed on the result, but we disagreed on the reasoning, and that was true in certain cases, in certain important cases this year. But it is sort of striking, I think, that in a lot of cases, people with, different judicial philosophies,
Sure.
different, actually see it the same way. And so that suggests that we're closer than people think we are. So I guess that's one thing.
Last term, you wrote opinions dealing with visa eligibility dates for children, religious prayer in town meetings, use of a gun in drug trafficking cases, sovereign immunity for Indian tribes, taxpayer relationships with IRS agents, government employee union fees and free speech, federal bank fraud, who is a purchaser of a gun. How do you handle such a wide range of topics and coming up to an issue you've never thought about before in a field of law you've never seen before? How do you do that?
Well, first, I think it's one of the great things about the job, and because I'm essentially a dilettante, which is to say, I've had actually in a lot of jobs that I've had a pretty wide breadth, and I don't know as much as the world's expert in any particular area. But what matters to the job is the ability to just cut across a very, very broad swath of issues and to know enough and to do a good job at that. And some people are kind of people who want to plumb the depths, and some people are people who in their jobs would actually rather do something new every day. And I think I'm more comfortable with the latter. I love the fact that every day presents a new issue and a new case and something I haven't thought about before and something I need to learn. So if some lawyers, and I think this is almost temperamental, right? Some lawyers create careers in which they just go deeper and deeper and deeper into one thing, and some lawyers create careers in which they do a whole world of things, and you have to kind of know what kind of person you are. And I'm the second kind of person, and for me, that feature of the job is one of the really great things about it.
You get to learn new things all the time.
Yeah.
Talk about dissenting. Do you like to dissent? How do you decide to dissent? When is it important to write a dissent yourself, even if there's another justice who's dissenting?
Well, different dissents serve different functions. I mean, dissents on our court usually are assigned in a similar way to majority opinions, that the most senior justice in the majority will assign the majority opinion, so that's the Chief Justice if he's in the majority. If not, maybe it will be Justice Scalia, or maybe it will be Justice Kennedy. And then usually the most senior person on the dissenting side will assign the dissent. So I think I wrote only 2 dissents last year, and they were both assigned to me by Justice Ginsburg, but I've had dissents which have been assigned to me, for example, by Justice Scalia. And so, I've not done one where I just say, I've not actually ever dissented alone when it, 8-1 and I'm the one. Nor have I done one where I said somebody else was assigned to dissent, but I just feel a need to write myself, which you can do.
And many of your colleagues do.
Yeah. But for me, I usually vote, and I usually accept assignments, and I am both on the majority and the dissent side. I'm pretty thrilled with the assignments that I've gotten, and then different dissents serve different purposes. Sometimes you're just kind of registering your disagreement, and it's on an issue that's not the world's most earth-shattering issue, and it's more important that the issue be decided than it necessarily be decided one way. But still, you think the court got it wrong, and maybe you think, it's important to register that. It's important that the parties know that this was a pretty close case, that there was an opposite point of view that was taken very seriously and that in fact was agreed to by some number of justices. But you don't, that you're going to write this dissent, and then that will be that. You'll never think about the issue again, and the court and you will go on as though the dissent hadn't been written.
It's the essence of our teaching. We use them all the time, right?
Yeah, but then some dissents are, you're trying. I mean, some dissents you're very aware that this is one where you hope 10 or 20 years down the road the court will see the matter differently. And writing that kind of a dissent is a very different enterprise, because you're sort of like writing for some future court, for some future justices, who you hope will look at the same issue or a similar issue, and really think that the majority got it wrong and you got it right. And those dissents are going to read very differently because they serve different purposes and they're designed to do different things.
You dissented in the case of the town of Greece that dealt with a practice of having prayer before a town meeting. And Sandy Levinson, professor at the University of Texas Law School, says it is a dissent worthy of the canon and wonderfully accessible prose that should be read by newspaper editorial writers, ordinary readers. And you said in that dissent, you begin, "For centuries now, people have come to this country from every corner of the world to share in the blessing of religious freedom. Our Constitution promises that they may worship in their own way without fear of penalty or danger, and that in itself is a momentous offering. Yet our Constitution makes a commitment still more remarkable, that however those individuals worship, they will count as full and equal American citizens. A Christian, a Jew, a Muslim, and so forth, each stands in the same relationship with her country, with her state and local communities, and with every level and body of government."
Okay, enough.
Okay, it's powerful. It's powerful. Any comments?
I believe that.
Okay. What would you?
You know what? For the most part, I do think that our opinions speak best for themselves, and I feel that about that opinion. I mean, it's like that opinion said all I have to say about the subject, and if I tried to talk about it, it would not be as good as that opinion.
Well, that's a lot of what novelists say too, right? Read the book, right? In a minute, I'm going to open this up for questions, and there's some mics here, and so be thinking about your question. But I do have one or two more that I want to ask. You've been on the court now several years. What do you wish you had known?
5. This is my 5th.
Wow.
I mean, so 4.
4
yeah,
already,
yeah.
and it's already your 5th. What do you wish you had known before?
Like the single piece of wisdom.
Yeah,
I honestly, maybe I'll go home and I'll think what the answer to that question was. But right now,
stumped her. Look at that.
It's not occurring to me.
No.
But I would say this. I guess because I learn something every day, and some of it might be about some area of law that I knew nothing about. Some of it might be about ways of dealing in an institution that still there's lots to learn about. I sit in Justice Stevens' chair. Justice Stevens was my predecessor. And when he resigned, and he was 90 years old, and he had been a justice for 35 years. And he gave a number of interviews when he stepped down. And in one of them, he basically said, the amazing thing about this job is I learn something every day. And I read that, and I thought, what an incredible thing. The man's 90 years old. The man, has served in the same job for 35 years. The ability to say that, to sort of approach every day as though there's something to learn here that I didn't know before, is a gift. And I don't think I have that temperament to the extent that he did, but I wish I did. And I've only been there for 4 years, but I feel as though every year I look back and I try to figure out, what did I learn this year? And there's a whole host of things, and I hope that continues on into the future.
Great. What piece of advice would you give to people who are starting their study of law right now?
Be open to new things, to new possibilities. Some people come in, and some people already know what they're interested in, and that's great. But even for those people, to be open to new things, because law school can surprise you. All of a sudden, you'll be in some class that you never thought you'd like, and you took only for some screwy reason, like it was at the right time or something, and it's like the best thing you ever did. And so to try new things and to be open to the fact that some of them may have really unexpected, just effects on you. And so to do that, to take more risks than you think you should. Law students are too risk averse generally. You're here at Harvard Law School. That's a really great place to be. It gives you a platform to be able to take risks. You should take advantage of that. And to be aware that you learn as much from your peers as from your professors. Not that there's anything wrong with your professors, but one of the great things about being in this institution is that you're here with a whole ton of really incredibly interesting and smart and nice people, and to take advantage of that. So I guess those are my
That's
3
great.
pieces of advice.
Those are really good. We have students here in both the JD and LLM program from 74 countries this year.
Wow.
Yeah, pretty good. Who's going to ask?
I have a couple in this class I'm teaching.
All right.
Yeah, they're very good. Yeah.
All right.
So.
And you're going to come back and teach next year, right?
Yeah, of course.
All right. Who's going to ask a question? Come up to a mic. Come up to a mic. Walk on over. And when you are there, please identify yourself by your name and where you are in your education. Let's start right here.
Okay. Hi, I'm Robin Ladd. I'm a 1L, Section 6. Woohoo.
Maybe talk a little louder into the mic.
I'm Robin Ladd. I'm from Section 6, and
Great.
I'm from Oklahoma.
Whoa, Section 6?
Section 6.
Whoa.
Awesome. So my question for you, Justice Kagan, is what was the most morally difficult decision for you to make in a case, and how did you grapple with the consequences of that decision?
What was the most difficult decision I had to make in a case? Well, I would, actually, the case where I kept on going back and forth and back and forth. For the most part, I'm not a Hamlet type by temperament. You know, I'm a pretty decisive person, and I don't, you know, I hope that I take decision-making incredibly seriously, but I don't have a lot of backing and forthing and angst over cases for the most part. The case where there were 3 different positions that ended up being expressed in the various opinions, and at one point or another I thought I could easily join any of the 3, was actually a First Amendment case. It was a speech case that was a long time ago now, but it had to do with violent video games and kids' access to violent video games. And that was one where I thought that all of First Amendment doctrine pushed one way and all of common sense pushed another way. And so that was very difficult for me. And, but I ended up going the way that I thought that the First Amendment doctrine pushed, and that was to invalidate a statute that tried to restrict the ability of kids to buy extremely violent video games. And I actually did have a lot of angst about that. You know, if I were a parent, I wouldn't want my kid looking at those games. And the idea of saying that a kid without a parent shouldn't be able to buy some of these games, you know, struck me as eminently sensible, and one of the things, like something I would have voted for if I were in the California state legislature. But I thought that I couldn't figure out a way to square that result with essentially the First Amendment rules that the court had. So so that's the way I went, but I found it a really hard one.
Thank you.
Thank you very much for a fascinating talk. My name is Yotam. I'm from the LLM program from Israel. When you were talking about the audiences of your opinions, you mentioned scholars, you mentioned the public, you mentioned a lot of people. I noticed that you didn't mention the appellant, the petitioner, the person that his matter is on stake. And I wonder if it's because it's hard to see this person from the bench. Is it because at the stage where it gets to the Supreme Court, it doesn't matter anymore?
Yeah, no, I think actually, if I didn't, that was an oversight.
No, you
and
did.
In fact,
You referred
when I
to-
talked about
yeah,
dissents, I
yeah.
specifically said that I want the litigants to know that they raised good arguments that
Were heard.
and
Yeah.
that actually persuaded some number of justices. But I think you're exactly right. Now, I think you're right. It's, you know, sometimes it's hard to see those people, right? Unlike at a trial court level, appellate courts, the issues are abstracted often, and the people kind of go away. But I think the people in all of these cases deserve to have opinions that they can read, and you know, half of them are not going to agree with them. Half of them are going to be very disappointed, but that they can at least sort of look at and understand that we took their case seriously, and that we thought hard about it and can understand, you know, why we did what we did.
And tried to explain it in terms that they could understand.
Yeah.
Yeah.
Hi, I'm Miranda Jones. I'm a 1L in Section 7. And thank you so much for speaking with us today. It's really educational. I was wondering, what advice could you give those of us who are interested in pursuing a Supreme Court clerkship?
You know, it's a kind of fluky thing. So I would like not set that as the goal if it happens.
Okay.
If it happens, that's nice. People
Right.
say this to me all the time. What did you do to get, you know? And it's like, really, come on. I mean, it's the, you know, there are some things that are sort of stroke of lightning kind of things. But you know, it's a great job if it happens. But I would just like enjoy yourself and
All right. Thank you.
no, I mean, yeah, it's good that people take you know, take it seriously, you know, and also enjoy yourself, and take it seriously and also enjoy yourself. Okay.
Hello, my name is Nina Monet. I'm in Section 4, and I'm coming from Eastern Michigan University. First, I just want to speak
I'm
on
sorry, you're
Section 4.
uh-huh.
Wow.
And I want to speak on behalf of everyone who just finished their first week of assignment, saying thank you for making your opinions readable. So I've had this question posed to me a lot by professors, so I want to pose it to you. Why are justices of the Supreme Court in any better position to say what the Constitution means than anyone else in this room?
You know, I'm going to say I know more than most of the people in this room. At least I hope I do.
Well, what's the phrase? You're not final because you're infallible. You're infallible because you're final.
Yeah. You know, I have to say, I don't spend a lot of time, I hope my colleagues don't either, I doubt that they do, thinking about whether I, rather than other people, deserve this honor. I mean, it's a stroke of lightning when it happens to you. It's a lot of chance that the 9 of us are there rather than 9 other people. And all you can do is try your best to, to do the best job you can. And that's all you can do.
Thank you.
Yes.
Gian Favors. I'm in a 1L in Section 5.
I'm glad we have this section loyalty going here already, yeah. Because I feel like we're going to have color wars right now.
Perhaps following up a bit, could you maybe comment a bit about the process of being vetted for the Supreme Court? What that was like? And I wonder as well if you could talk a bit more about conference and I guess when the doors close to that very great judgely room, whether and how often some of your fellow justices may be swayed by the arguments or the exchange or discussions that happen there?
I think more than people think, although not in every case. I mean, sometimes you go around the room and everybody votes and there's no swaying to be done. I mean, sometimes it's because actually we all agree with each other. So there are some number of cases, and the chief always starts and he always says, here are the issues and here's how I would come out. And on one of these sort of unanimous type cases, you'll often hear from the chief and Justice Scalia and Justice Kennedy, and maybe by the time they're talking, they've finished talking. If everybody else just agrees, everybody will just say, I agree, I agree, I agree. I mean, sometimes they can be that fast. Sometimes there are cases where we disagree, but there's going to honestly, everybody knows that there's not a whole lot of persuading to be done. And I remember my first conference, we had 2 cases in front of us, and one of us was the kind of case that was going to get front page treatment in the New York Times. It was the kind of case that everybody was focused on, and the other was this totally abstruse procedural issue. And we did the procedural issue first, and it took a long time. We were a little bit fractured at the beginning, and we were really trying to figure out how to reach consensus on this, and we were really trying to figure out the right answer as well as to persuade each other. It was fantastic discussion of a kind that, as I say, we have not infrequently. And it took about 40 minutes, and then, I thought, well, the next case, how long is the next case going to take? And the next case was like, everybody said their piece, all 9 of us said their piece, and then it was done. And I thought, first I thought, that's sort of peculiar. If you told somebody we spent 40 minutes on this case and 10 minutes on the next case and had a lot of interchange and back and forth on this case and almost none on that case, they would think you're crazy. But, there are some cases where we kind of know where we are and we're not going to convince each other. And I think, honestly, there's a kind of sensible, almost unconscious decision. At a certain point, you just don't rub it in, We agree to disagree, and we're not going to make ourselves feel better about the institution by telling each other 22 times why we disagree. So, but then there are these other times where, and not just in arcane cases, but in cases that matter, where some people are really uncertain. Maybe everybody is really uncertain because it's unbelievably hard, but often cases where at least a few people are really uncertain. And there is a lot of back and forth and a lot of attempts to persuade, and that's just tremendously fun and exciting to be part of.
I think we're just going to take 1 or 2 more, so let's go.
Hi, I'm Pat Minow. I'm a 1L in Section 3. And
I'm sorry, no applause for Section 3.
Yeah. Oh, man.
Everybody's embarrassed by my color war remark.
We do have good cohesion, unit cohesion. You pointed out that you sit in Justice Stevens' seat, and he's been rather vocal recently about amendments to the Constitution that he thinks would be reasonable. And obviously, he has a lot more freedom now than you do currently. Can you talk about some ways in which, either in the medium term, the Constitution, you anticipate some changes that might be sort of reasonable in actually the text of the United States Constitution, either in the medium term to deal with legal controversies that are particularly difficult, or if you can't speak about that, maybe in the longer term to deal with broader changes that happen over a longer time span, such as the changing diversity of America, or...
Not my job.
Yeah.
I feel very strongly about that, actually. It's not my job. I mean, if there are people who want to amend the Constitution, all power to them, go ahead. But my job is to interpret as best I can and apply as best I can the Constitution that we have. Just as when we do statutory interpretation, I might have 1,000 ideas of new statutes that Congress could come up with, but that too is not my job. And my job is to interpret and apply as best I can the statutes that Congress passes. And you have to know sort of your role in the governmental system, and the role that I have, it's like enough, it's big enough, and it would be actually inconsistent with that role to try to sort of reach out and do other things. So not my job sounds a little bit flip, but it's actually quite a serious statement about what a justice is supposed to do and what a justice is not supposed to do.
So just two more.
Good evening. My name's Theodore Yale. I'm a 1L from Section 5. Thank you. Going back to your color
Why are all
wars
these people
comment,
so dressed up?
I've noticed that in the pub, in the basement here, the walls are red, and when the lights are turned on, they turn a brilliant shade of orange. And I'm wondering if there's any subversive school loyalties at play behind that color choice.
Subversive school loyalty? I'm sorry.
Princeton.
To turn
Princeton.
to surround Harvard in so much orange.
I hadn't really thought of that.
Okay. Well, but about the about your job on the Supreme
You have a
Court.
second question.
Yes. Less important. But I'm wondering if you can comment a little bit on judicial independence. I know a big sort of intellectual topic that gets debated is the accountability of the Supreme Court, if there is not, if not having them being politically accountable is a good thing or a bad thing. I'm wondering if you can just tell us about your personal experiences on that front as a young and relatively new justice, if there have been any moments where you felt like, wow, like I really am independent and I can make a decision that I might not have made if I'd been in a politically under the microscope.
Yeah, well, I think you feel that right away, and I think that's true for all of us, that you get into this job and you go through this confirmation process and you come out the other end with a job unlike any that you've had before, and a job that you're going to have for the rest of your life, and a job in which you are not accountable to any other actor in the political system, and where your job is to do what you think is right on the law, regardless what that's an incredible responsibility, and I take it seriously, and I think all my colleagues take it seriously, and but it's I mean, you can't help feeling that way about this job, is that there are the 9 of us, and we do not report to anybody, and we have our jobs for as long as we want them. And that makes you say, every case that comes before you, I'm going to take all the arguments that different people and different actors in the political system are making, but, I have to decide myself what I think that the law is best interpreted to say.
Last question.
Hi, I'm Robert. I'm from Section 2. I'm a 1L. My question is, I was wondering if you could explain a little bit more the process of granting certiorari. Is it a negotiation? Is it a discussion? Is it like when you make a decision and the most senior justice goes first and then you go around the table? Does it get very heated? How does that work?
Taking cases, in other words, the
Yeah.
process of taking cases. There's actually a funny thing that I saw about the different ways of pronouncing certiorari. And there was
Latin, we can say whatever we want.
whoever wrote this blog sort of talked about 3 justices say it this way, and 2 justices say it this way. And we don't know the way Justice Kagan says it because, and it's true, I sort of plan my sentences never to have to say that word. We get almost 10,000, I think it's like 9,000 petitions every year, and we only take about 80 of them, 75, 80, which some people think is too few. Some people think we ought to do better and take more. But even at the height of Supreme Court practice, I mean, maybe they took 140. So there are a huge number that, almost all of them are rejected. And we go through a big process of, most of us are in what we call a cert pool, and different clerks around the court write memos on every single one of the cases, and then we get those memos, and some of us have our own clerks look at all those memos, and so we get advice as to whether this is a case that we should take. And then we apply a set of criteria. And the probably the criterion that leads to the most grants is just what I said before, is division within the lower courts. So if the Sixth Circuit decides a question this way, and the Second Circuit decides a question that way, we think that the law should not be different in Ohio than it is in New York, the federal law. So that's the reason we take most of our cases. Some cases we take because it's just obvious that these issues are of such magnitude that regardless whether there's a split, it's the Supreme Court that given the importance of the issue for the nation, it's we who should decide it. We all come into conference. Of the 10,000 petitions and that many memos, they're interspersed throughout the year. Anything that any one person wants to discuss gets put on the agenda at conference. It's called a discuss list. So if I want to discuss a case, if I think cert should be taken on a case, I just put it on, I say I want to do that, and then we will discuss it. And then it takes 4 votes to actually grant it. And yes, we will go around the table in the typical seniority order, and it will always start with the person who puts it on the discuss list. So in that case, like if I've put something on the list, I'll go first and I'll try to explain to people why I think we should take the case, and then it will go with the Chief Justice and around the table, and if it gets to 4, then we take the case.
Has it ever been the case that a case come up that you feel personally strongly about, and maybe doesn't fall into the previous 2 categories you mentioned, and so you personally make a case to take this case?
You've asked a second question. You don't have to answer it.
I don't?
No.
No. Well,
It's okay.
you know what? If it's an issue that's important enough, if the court doesn't take it one time around, Justice Kennedy, I remember, once said this to me at the very beginning. He said, you put something on, if the court doesn't take it, and you're right that in fact it is important, it will come up again. So.
Thank you so much.
I want to say to you, as your former teacher, I hope you come up again here, because it's just a thrill to have you back.
It's a thrill to be back. Okay. Here we go. Thank you all.
You want to go back?